Welcome to the Law Professor once again. In this presentation, we shall be looking at differences. We want to compare the desertion provisions of the Matrimonial Causes Act with the living apart provisions of the same act so that you would be able in needed situations to determine which provision to apply. As we go along, please don't forget once again to like this video, share it, and to subscribe to this channel for greater coverage. The Matrimonial Causes Act makes provision for dissolution of marriage, and within the components of that act, there are provisions that relate to desertion under Section 15(2)(d) of the Matrimonial Causes Act, and the living apart provisions contained in Section 15(2)(e) and F of the same statute. What is the relationship between those two provisions? Under the Matrimonial Causes Act, the law provides that the parties could bring a petition for desertion, for dissolution of marriage, on the basis that a fact of the desertion is established for a period of at least 1 year immediately preceding the presentation of the petition. While Section 15(2)(e) talks about the fact that parties have lived apart for a continuous period of at least 1 year immediately preceding the presentation of the petition, and the other spouse does not object to the petition being brought, or the parties have lived apart continuously for a period of 3 years. Now, one of the similarities that we can see in those provisions is the fact that both all are facts of irretrievable breakdown of marriage, and if you are able to establish any, then you be able to prove that the marriage has broken down irretrievably. And these provisions all require some form of separation, whether physical separation or emotional separation. There is coupled with the needed mental element, either for desertion, an intention to bring cohabitation permanently to an end, or for living apart provisions where there is an intention to bring the marriage to an end. Now, how can we compare these provisions? The differences are in this, some of them at least. The desertion requires separation for 1 year. In the living apart provisions, you need separation for 2 years for Section 15(2)(e), or separation for 3 years for Section 15(2)(f). Now, in desertion, the deserter must form the animus diserrendi. It forms the intention to put the marriage to an end, cohabitation to an end permanently. It is the deserter that forms that intention, and that must be established to have run with the physical or emotional separation for a continuous period of at least 1 year. In the living apart provisions, either partner may form the intention to end the marriage, and both partners could actually form the intention to end the marriage. So Mrs. A leaves the marriage, intends to come back, but the husband has decided that he will not accept her back because she left the home without his consent. He forms that intention. So where it might seem that Mrs. A has left the home and maybe she has a just cause for leaving, maybe for assuming she went to go and take care of her aged mother that is critically ill, and the husband does not want her to go, or she gets a job or she gets transferred. She has a just cause for leaving. She's not in desertion. But the husband forms an intention right there and then to put the marriage to an end. This husband or this wife, either of them, forms that necessary intention. That's another distinction. Then there's lack of the consent of the non-deserter spouse in the desertion. In these living apart provisions, in a technical note, consent may not be so material. It may not be so material. Then in a desertion scenario, it innocent spouse, if you can put it like that, who brings the petition and alleges that the respondent has deserted the home. So when you have a petition being brought, look out for the person bringing the petition. It is the innocent spouse that is able to rely on that desertion provision of Section 15(2)(d) of the Matrimonial Causes Act. In the living apart provisions, it's actually immaterial who brings the petition. It might be the person that left the matrimonial home to live apart. It might be the person that stayed in the matrimonial home. Either of them could have brought the petition and carefully, without the need to show that they are innocent or they are guilty, because the living apart provisions are actually the real no fault divorce provisions. So it is immaterial that, oh, the husband, for instance, who forms the intention not to accept the wife back, in the example that we are giving, is one that is also bringing the petition, or is the wife who left physically that is bringing the petition. These are immaterial considerations. Of course, we know that there are some bars to divorce that weigh in the decision of the court in terms of whether there's conduct conducing, condonation, and all those things. Okay. Now, desertion imports the concept of a matrimonial offense. It's in the old matrimonial offense regime. It is a major matrimonial offense to commit adultery or to desert the home. But living apart does not import any ideology of offense, of wrongdoing, so to say. It doesn't really import that. It doesn't import that. There's no offense theory engaged in the living apart provisions. So you can actually bring the living apart, bring a petition for decree of dissolution of marriage within the living apart provisions effortlessly. There is no need to show that there is an offense, there is a fault, there is a wrongdoing. If you look at the case of Ladipo and Ladipo, where the husband packed the wife's clothes out of the matrimonial home, sent her back to her parents' home, and refused to accept her back. And doing that for a continuous period of 2 years entitles him actually to bring a petition on the fact that they have been living apart for 2 years, provided the wife has not objected. Of course, the wife objects in this context. It would, and that would not have, in that case, that could be, that would prevent the petition going ahead. But if the wife does not object, it would actually succeed in that petition. And if it was for a period of 3 years, then the husband gets that decree granted on the basis of them living apart for 3 years. So the 3-year separation is divorce that is of the innocent. The 2 years separation, in fact, allows non-acrimonious divorce. Once the other party does not object, there's no acrimony, there's no need for conflict or dispute for opening any Pandora's box. You get the divorce granted. The 3 years separation can still be a bit acrimonious if the other person is saying, look, I don't want the divorce, I don't want it to be granted, but the court is not really going to consider that. It's a no-fault regime and actually makes room to divorce an innocent spouse. You can't come to court and come and tell the court that we fell out of the law. You must actually show to the court that you need one of the matrimonial facts in Section 15(2) of the MCA or 16, right with Section 16, has taken place in your marriage. But if you fell out of love, for instance, you can stay apart for 2 years or stay apart for 3 years and bring a no-fault divorce before the court. The court may use its discretion in a desertion case and say, despite the desertion, it may not necessarily be disposed if there's other things in place. We've talked about, we are talking about the fact that there can be bars to divorce and discretionary bars exist. But in the case of the living apart provisions, once the living apart for 2 years or 3 years has been established, then you can actually automatically get the decree of divorce being granted. So these are some of the considerations that distinguish these provisions. Divorce of the guilty is what is implicit in the desertion case. You are saying the person's he has left the home without a just cause, without the consent of the other spouse. So there's an element of guilt in the desertion provisions. In the no fault provisions, we talk about divorce of the innocent is possible. It's possible. Of course, in real life, they would not actually separate if there wasn't something or the other in terms of maybe behavior of that provisions, conduct provisions have been infringed upon. But when you want a situation where you don't really want to be talking about all those in the public, in the court, then you have situations where parties just separate and just bring a simple application for divorce on the basis of their living apart. We've talked about the issue of physical living apart and emotional separation in other videos. Then the desertion, of course, the elements of desertion are what we are emphasizing. Lack of just cause must exist. In the divorce in the living apart provisions, whether there is a just cause for living apart or not, if there is that element of a decision by any of them that they would bring cohabitation to an end, they bring conjugal relations to an end, you can actually get a divorce, even when the other person has left. For instance, the wife says, I want to go abroad for greener pastures. And the husband says, no, I don't want to go. I want us to stay in Nigeria. And the wife disobeys. She doesn't, and she intends to come back. She still believes that she would come back and she will send people to appeal the husband, but she thinks that she ought to go. And she goes without his consent. And the husband decides right there and then to not to accept her back. She might have gone as for her to constitute to be a deserter. She doesn't tend to bring cohabitation permanent to an end. So you might say that the element of the desertion is not complete, even though technically that could also be a desertion. But really, the husband who forms the intention not to accept the wife back in such circumstances has formed an intention to bring conjugal relations to an end. And petition can be granted on the basis of them living apart. Even when the wife says, please, I don't want this marriage to end. I think I want the best interest of the family at heart. I wished my husband would accept the fact that we needed to get more financial stability. And that's why I'm working myself to, to be sure that we have better life. So she may appear to be the innocent spouse in that context. But once one of them forms that intention that the marriage has come to an end because he or she is not going to accept the state of affairs, then if the time runs for 2 years or for 3 years, depending on the one that is being brought before the court, the living apart provisions would have been met. So those are some of the considerations